Hello, everybody. I'm Seth Weissman, and welcome to another episode of Safe Real Estate. One question which I get asked a lot is whether there's an obligation to disclose a defect which has been repaired. And the technical answer to this question under Georgia law is no. In Georgia, a seller must disclose latent or hidden defects known to the seller, which could not be discovered upon a reasonable inspection by the buyer. But if the defect has been repaired or corrected, it is no longer a defect, and technically there is no longer an obligation to disclose it. So if the seller simply fills out the short form seller's property disclosure statement, which simply asks the question, are there any known latent defects? The seller can answer that question no in good conscience and move on. But if the correction of the defect fails and no disclosure has been made, if all you do is disclose nothing, you may well be inviting a lawsuit from the buyer who now argues that you knew that there was a defect, you knew it was not properly corrected, and you failed to disclose it. So I would argue that on balance, it is probably better to make full disclosure to the buyer, because if you say to the buyer, hey, we had a leak in the basement, but we hired a professional waterproofing company, they waterproofed the house, and we've not had any problems since. If there is now a further leak, the buyer is more likely going to focus on the waterproofing company rather than the seller. So no technical obligation to disclose, but in many cases there are probably some good business reasons to make full disclosure. I hope this episode of Safe Real Estate has been beneficial. As always, it's great to see you. Please continue to tune in. Bye now.